Good evening. My name is Thomas Short. I'm a third-year law school student at Washington Lee. I would like to welcome you all to the faculty preview of the Supreme Court of the United States October term. This is a brilliant event. We get to hear incredible presentations on cases soon to be heard by the Supreme Court, and they were delivered to us by a group of some of the law school's most prestigious professors. Most importantly, for those law students in attendance, there was no reading assignment for this presentation, and no one will be cold called. This really is...
I got a question for you.
Whoops, sorry guys. Sorry. So, this really is an all-star panel. In fact, this panel is so prestigious that a full or even adequate introduction of these panelists would take over the hour and a half we have allotted for the event. With that said, I must apologize to our panelists. My introductions will be brief and will focus primarily on the role that they play at the Washington Lee School of Law. In order of appearance, we have Professor Ann Massey, presenting Town of Greece v. Galloway. Professor Massey teaches constitutional law, biomedical ethics, and is an expert on church-state issues. Professor Massey is the faculty advisor for the Journal of Civil Rights and Social Justice and has been a member of the faculty at Washington Lee since 1985. Next, we have Professor Mark Drumble, presenting Bond v. United States of America. Professor Drumble teaches contracts and international law and is an expert on public international law, global environmental governance, international criminal law, post-conflict justice, and the transnational legal process. Next, we have Professor Christopher Seaman, presenting Mccutcheon v. Federal Election Commission. Professor Seaman teaches courses in civil procedure, property, intellectual property, and a seminar on election law and voting rights. Professor Seaman's research focuses on intellectual property litigation and remedies for violations of intellectual property rights. In addition, Professor Seaman has an interest in voting rights and election law, having written several articles on the history, constitutionality, and potential future of the Section 5 of the Voting Rights Act. Next, we have Professor Russell Miller, presenting the American Lung Association v. EME Homer City Generation. Professor Miller teaches constitutional law, comparative law theory and methods, comparative constitutional law, German law and legal culture, and public international law. Professor Miller is the co-editor-in-chief of the German Law Journal, an English language journal reporting on developments in German, European, and international jurisprudence. Next, we have Professor David Bruck, presenting Bert v. Titlow. Professor Bruck leads Washington Lee's Death Penalty Defense Clinic, the Virginia Capital Case Clearinghouse. VC3, as it is known, is a trial-level legal aid clinic that provides free services to defense attorneys who represent capital murder defendants in Virginia. The clinic is staffed by third-year law students, Professor Bruck has argued 7 death penalty cases in the United States Supreme Court and over 70, that's 70, capital appeals in state and lower federal courts. Finally, we have Professor Brian Murchison, presenting NLRB v. Noel Canning. Professor Murchison teaches torts, American public law process, affectionately known as APLP, or admin law, as well as mass media law. Professor Murchison has been with us at Washington Lee since 1982. Before we begin, a quick note on procedure. Each faculty member has been allotted 15 minutes for their presentation. We hope that roughly 5 of the 15 will be reserved for questions, giving each professor roughly 10 minutes in which to provide their summary analysis. So if you follow me, every professor will speak for roughly 10 minutes. We'll have roughly 5 minutes of questions for that professor before moving on to the next professor. Although there is some time at the end of the presentations as a whole for follow-up questions. I'll be moderating the question and answer sessions, so please raise your hands if you have any questions. Professor Massey, if you'd be so kind.
Good afternoon. Thank you for coming out on this beautiful sunny day. As Mr. Short told you, I will be talking about Town of Greece versus Galloway. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Thus begins the First Amendment, thereby setting forth what is often called our first freedom, religious liberty. But what does it mean? especially what does it mean for government, federal, state, local, to establish religion? The Supreme Court's been struggling with that question for a number of years and has never given us a clear-cut answer. But this year, for only the second time in its history, it will be tackling the issue of legislative prayer in Town of Greece versus Galloway. The Town of Greece, New York, is located near Rochester. Beginning in 1999, the town changed its former practice of beginning its monthly town board meetings with a moment of silence and instead switched to having a prayer offered by a local chaplain of the month. These clergy came from local houses of worship, contacted by means of their appearance in the telephone directory or a list from the local Chamber of Commerce. The clergy were almost invariably Christian, and their invocations frequently called on the name of Jesus Christ, invoked the prayer in his name, or made some reference in the course of the prayer. Two women who frequently attended the town meetings objected to this practice and made known their objections in 2007. So in 2008, the town went to special efforts to locate some people from houses of worship just beyond the town limits. And that year, they had one prayer offered by a Wiccan priestess, one offered by the chairman of a Baha'i congregation, and two offered by a Jewish layperson. But in the year after that, they basically went back to their old practice of having local clergy, and they were offering Christian prayers. So in 2010, plaintiffs Susan Galloway and Linda Stevens brought suit, claiming that the prayers violated the Establishment Clause of the First Amendment, in that the town had aligned itself with one religious group, Christianity. The Federal District Court for the Western District of New York granted summary judgment to the defendants on the grounds that the prayer policy was constitutional under Marsh v. Chambers. Marsh versus Chambers was a case decided by the Supreme Court in 1983. In that case, the court upheld the practice of legislative prayer on the grounds of history. The very first Congress had a chaplain who offered prayer at the beginnings of its sessions. In fact, so did the Continental Congress before it. And that first Congress was also the one that drafted the First Amendment. So, reasoned Chief Justice Warren Burger, surely that Congress would not have drafted an amendment that they themselves thought they were violating. So they had to think that legislative prayer was compatible with the meaning of the First Amendment and its Establishment Clause. Marsh versus Chambers upheld, therefore, the practice of a paid Presbyterian chaplain who prayed at the legislative sessions in Nebraska, the state legislature. He offered prayers in what was called by the court the Judeo-Christian tradition, although he did omit references to Jesus Christ after a Jewish legislator protested. So, in that guise, the District Court for the Western District of New York found that the legislative prayer of Town of Greece was perfectly valid so long as it did not, quoting from Marsh, proselytize or advance any one or disparage any other faith or belief. But Marsh is the court's only case dealing with legislative prayer. And in that case, it failed to apply any of the criteria or the tests that it usually applied in Establishment Clause cases. It just said history, and that was pretty much it. Hoping for a better result, or at least maybe a more nuanced analysis, the plaintiffs from the original case appealed to the Second Circuit Court of Appeals. They attempted not to have the practice of legislative prayer invalidated altogether, but to convince the court that the prayer policy, as followed by the town of Greece, amounted to an invalid practice because of its overwhelmingly Christian nature. The Supreme Court has said on numerous occasions that the Establishment Clause means the government may not favor one religion over any other, or, for that matter, religion over non-religion, or what the court has sometimes called irreligion. Writing for the Second Circuit, Judge Guido Calabrese reversed the district court and remanded the case. Applying Justice O'Connor's endorsement test to the town of Greece's prayer policy, he stated, quote, "We must ask whether the town's practice, viewed in its totality by an ordinary, reasonable observer, conveyed the view that the town favored or disfavored certain religious beliefs. Whether the town, through its prayer practice, has established particular religious beliefs as the more acceptable ones, and others as less acceptable." Judge Calabrese found the answer to this question to be yes, holding therefore that, quote, "looking to the totality of the circumstances, the policy must be viewed as an endorsement of a particular religious viewpoint." The town of Greece appealed this ruling, and the Supreme Court granted cert. The case will be heard on November 6th. The question presented is stated as whether the Court of Appeals erred in holding that a legislative prayer practice violates the Establishment Clause, notwithstanding the absence of discrimination in the selection of prayer givers or forbidden exploitation of the prayer opportunity. This very wording doesn't sound very propitious for the respondents here. But their brief presents an argument not entertained at the lower court levels. Their tactic is called by commentators the "get Kennedy's vote" ploy. Respondents are now arguing that the town's prayer policy, quote, "puts coercive pressure on citizens to participate in the prayers, and those prayers are sectarian rather than inclusive." Reference is thereby made to Justice Kennedy's coercion test, formulated in the dissenting portion of his opinion in Allegheny County versus ACLU, Greater Pittsburgh Chapter, 1989. Kennedy disagreed with the majority that it was impermissible for a Roman Catholic society to place a creche at the foot of the grand stairway inside the Allegheny County Courthouse. Justice Kennedy argued that prior cases disclosed only that, quote, "government may not coerce anyone to support or participate in any religion or its exercise." Respondents claim that when attending Town of Greece meetings, they are actually coerced to participate in a prayer with which they do not agree. If they do not participate, at least by bowing their heads respectfully, or maybe standing if the prayer giver invites that response, they are looked upon with suspicion and disdain by the other persons attending the meeting, and even by the members of the town board itself. In Allegheny, Kennedy made clear his view that the coercion test was the only approach that would permit what he considered appropriate accommodations to the religious sensibilities of most of the nation's people, including, for instance, the opening of the court, "God Save the United States" in this honorable court, the inclusion of "Under God" in the Pledge of Allegiance, and the use of the national motto, "In God We Trust," printed on all of our coins and dollar bills, all of which he considered completely acceptable. These are some of the elements of what has often been referred to as the American civil religion. Considering Kennedy's view, respondents are seeking hard to convince him that the town of Greece's prayer policy fails to meet his coercion test. For their part, commentators and court watchers are looking to see whether this legislative prayer case, only the second in 30 years, will in fact give guidance as to the court's view on those examples cited by Justice Kennedy as permissible accommodations, the American civil religion. One thing unusual about this case, the Obama administration has stepped forward to support the town of Greece. Remember that President Obama, like all presidents before him, had invocations and benedictions at his inauguration ceremonies, also part of the American civil religion. Frankly, I don't look for it to be struck down anytime soon. Any immediate questions?
Approximately 4 minutes for questions. Anyone have?
Totally clear. Thank you.
All right, so good afternoon, all of you. And thank you. I want to echo Anne. Thank you for coming. I'm going to talk about Bond versus United States. This case explores the intersection of international treaties and the U.S. Constitution, and it's the big foreign affairs case of the year. Okay, great. There's not that many foreign affairs cases, but we've got one, and it's big. And it tells us 4 stories. And I'm going to get to the stories. But first, as always, let's talk about the facts. Carol Ann Bond lives in eastern Pennsylvania, and she has a husband and a child. She also has a best friend, and her best friend is named Merlinda Haynes. One day, Haynes tells Bond that she's pregnant, and Bond is very happy. Bond's happiness evaporates when Haynes tells her who the baby's father is. And the baby's father, as you've guessed, is Bond's husband, with whom Haynes has been having an affair. Bond vows to make Haynes's life, quote, a living hell. Unluckily for Haynes, Bond is a microbiologist. And in that capacity, she has access to lots of chemical goodies. Bond steals an arsenic-based chemical from her employer, and she orders other chemicals whose names are too long with too many syllables for me to repeat here. But she gets them on the internet. They're toxic, they're potentially lethal, although not in the quantities used. Okay, so what happens? Bond is adept at ordering chemicals, but she is not a sophisticated criminal. She spreads these chemicals over Haynes's door handle of her car and also the doorknob to her house. Problem, the chemicals are bright orange, so Haynes does not put her hand on them when opening the car door. The most Bond gets out of this is that Haynes gets a small burn on her thumb, and she puts it under the water, and the burn doesn't hurt anymore. Bond then goes further, and she ends up putting chemicals on the mailbox of Haynes. Haynes gets the U.S. Postal Service to install a camera. I don't really know how she managed to get this done, but she got it done. And lo and behold, the camera records Bond putting the chemicals on the mailbox, also stealing some mail, and stuffing the chemicals into Haynes' car muffler. Okay. The police arrest, and as I'm sure David and other criminal folks would say, wow, it's a local caper, not such a big deal. These things may not happen exactly like this all the time, but, you know, this happens. However, federal prosecutors get wind of this, and federal prosecutors get eager. They step in, and they enter this matter. And they charge Bond under federal legislation. The federal legislation is called the Chemical Weapons Convention Implementation Act. And it's enacted in 1998, and it's enacted, and here is the international hook you've all been waiting for, it's enacted to ratify an international treaty, the Chemical Weapons Convention, which the United States had signed and Congress ratified just 1 year after the United States signed it. So very expedient and very fast. This convention aims to ban the production, acquisition, and transfer of chemical weapons anytime by states and obliges states to criminalize this under national law. Bond is charged, and she conditionally pleads out to the charge of, quote, using a chemical weapon, and also to the theft of mail. That's separate. We don't need to worry about that right now. Bond is sentenced federally for all this to 6 years imprisonment, to be followed by 5 years of supervised release. After the conditional plea, she decides to challenge. And she challenges, in principle, the chemical weapons conviction on federalism grounds. She first, however, has to get standing to do so. There's an initial series of litigation involving the 10th Amendment. It goes up to the Supreme Court. Yeah, this is Bond's second trip to the Supreme Court. After her first trip, the United States Supreme Court grants her standing to challenge the charge on federalism grounds. But the court takes no position on the merits of her claim, remands, and it goes back down. The Court of Appeals then affirms the conviction and rejects the constitutional claim. In this process, the Court of Appeals adheres to Justice Holmes's view, taken nearly 100 years ago in a case called Missouri v. Holland, that, quote, if the treaty is valid, then there can be no dispute about the validity of the statute that implements it, and that is valid as a necessary and proper means to execute the powers of the government, the U.S. government, in international relations. Hence, Congress is granted a bit of a wide girth when it comes to enacting legislation, even if it might otherwise exceed its powers, if that legislation is necessary and proper to ratify the international treaty. The United States maintains that Congress has authority in the Bond case under first the Commerce Clause, and then secondly, and not ordinally, just secondly, the treaty power coupled with the necessary and proper clause, and it maintains that it is fine for it to prescribe Bond's conduct in the way that it did. There is also an amicus brief that's been filed, according to which 2 law professors and former advisors at the State Department argue that the offenses clause may thirdly justify this particular arrangement. There's also an interpretation issue. I won't get to it now. We can talk about it later in Q&A. It is possible that the court might simply interpret that the legislation is okay, but can't be extended to situations like bonds. But more interesting, and probably more live, is the actual constitutional argument here. I told you Bond tells 4 stories. So what are they? The first story is a simple one. It's one of over-criminalization. One would say, give prosecutors an inch. In this case, they've definitely yanked it a mile. Secondly, it's a story of constitutional precedent. Missouri and Holland involved a migratory bird convention, not nearly as exciting as chemical weapons. But it's been around for a long time. And the court has never invalidated a treaty implementing legislation on federalism grounds for these particular reasons. Holmes's statement in that case has been left undisturbed. So, predictively, what might happen? Well, we have seen that the Roberts Court has been activist on some constitutional matters, and we have also seen that it has taken a pretty rigorous approach to foreign affairs matters. For example, in the Medellin case, which all of you who at least did transnational last semester will know is another federalism case whereby the court took a very strict view of the interplay between the executive and Congress when it came to the validity of executive agreements. The federalism issue here isn't President and Congress. Congress passed the legislation. It's all valid. It's all good. It's all happy. The interplay here is between federal and the states, because it could quite be seen that a matter of police power and local enforcement is something reserved to the states. Keying off of prior jurisprudence, I would predict that this court may not necessarily take a perfunctory view that Missouri v. Holland applies, and that's it. We're going to go home. I suspect there'll be something more there. 2 more stories of Bond. It's a story of international relations. Look, invalidating legislation adopted to enact a treaty based on local conduct does run the risk of hamstringing American treaty negotiators when they negotiate international treaties and documents. And this is the position that the government takes to some degree. It also permits local opt-outs in this particular vein. On the other hand, it's hard to contest the reality that this treaty, designed to prosecute and control people like Saddam Hussein, Bashir al-Assad, individuals who peddle in chemical weapons, and states who may traffic in them, applies to a lost love in a relationship in the kind of incident we're talking about here. That said, it's not altogether clear that finding for Bond in this instance is going to be good precedent for the United States in its own treaty negotiations. It's already a nightmare to get treaties ratified domestically in the United States, all the more so given congressional dysfunctions. But even looking beyond that, we would add another layer of complexity here, of judicial micromanagement to these particular matters. Finally, though, for me, Bond is interesting as a story because it's totally counterintuitive. As international lawyers, we're always worried that the United States doesn't ratify enough, doesn't comply enough, doesn't domesticate enough, isn't doing enough. And we view that as sad, as a lost opportunity in many, many ways. But here, the United States, at least in terms of Congress, has done an awful lot. It has taken this treaty very seriously. It's domesticated it, and it has gone out of its way through the federal power to prosecute someone on it. It has breathed life into this particular arrangement. And to me, this is interesting because it suggests the following. International law is law like any other forms of law. And we think that the domestic ratification of international law, particularly international criminal law, like what we have here, to denounce the horrible use of chemical weapons. We think domestically ratifying stuff in this area is just, progressive, modern. We're sailing with the angels, and we're doing the right thing. Well, those of us who believe in sailing with the angels, doing the right things, justice, progressiveness, and human rights, would probably be a little bit uncomfortable with charging and convicting Carol Ann Bond as a chemical weapons warrior. And yet, that is exactly what has happened here. And to me, this tells a counterintuitive story of international law, and particularly international criminal law. It's law, and once it's on the books, it can serve good purposes. It can also serve purposes that are slightly less good. And in many ways, it can also attain repressive ends. And we'll see how the court sifts through all of that. Thank you. Oh, yeah, questions. Great. Am I over time? Or? A few minutes, okay, great. Any questions from anyone, or do I, no different than Professor Massey, get a free pass here? Yes, sir.
Is it true that she bought those chemical weapons on Amazon?
Yes, sir. Well, not the one, here, look, you want to get me to say it? I'll try to tell you what she actually bought on Amazon. I typed it out. I didn't highlight it, right, because I wanted to make sure. Potassium dichromate. Maybe, Chris, I'm mispronouncing it. You're sort of the science guy here. Yes, on Amazon. And the other one, the arsenic stuff, was stolen from her employer. It was a big corporation, not like a university. So yes. And they can be lethal in certain quantities. However, if we assume, so Bond says that she never intended to kill her, right? And if we assume a level of knowledge about the volume of chemicals that she spread out, then it's fair to say that she spread out the chemicals in a way that would not be lethal. But the prosecutors also had their own approach to this. For example, they cited 24 instances in which she attempted to poison Haynes. And also on a couple of occasions, at least if you look at the facts, Haynes was holding her younger kid, and her young kid maybe could have put some toy on the chemicals and put the toy in her mouth, and in a little body, who knows what might end up happening. But that didn't, none of those things actually happened. It could have happened. But yes, you're right. So we'll make sure that we'll keep you off of the web tonight, so that now that you know, right? So all right. Anything else? We're good? Yeah.
Just curious, was you trying to state law
No, it was as I understand it, it is the federal legislation grounded the criminal charges in this particular. Well, I don't know initially what may have happened in the police investigation, what sort of was embryonic at that stage, but I do know that certainly as characterized by the petitioner bond in this case, the federal authorities entered and federalized this in a sense, and turned it into something that involved this legislation in question, and have adopted a view of the statute as applying. So, the con law issue is one of the issues on which the Supreme Court granted cert. There is another one, okay, and that issue is an interpretive one, and it would have two subdimensions. It could be argued interpretively that the legislation satisfies Missouri v. Holland from the constitutional perspective, but interpretively never extended to the kinds of situations that Bond engaged in, okay? So it would mean the law is okay, but the fault lay in the actual interpretation. And that is one of the arguments. Closely related to that is the fact that there is an exemption in both the treaty and the ratifying legislation. The ratifying legislation mirrors the treaty. It does exactly. It's unusual for the U.S., for Congress, and the advice and consent of the Senate. It does exactly what the treaty says. There was no reservations, modifications, declarations, or anything. And both instruments contain the following exception. If your conduct under the convention is intended for, quote, a peaceful purpose, then you are outside of the framework of the statute. However, at the Third Circuit, and I'm sure the United States Supreme Court is probably going to chime in on this, it's very difficult to characterize Bond's behavior as peaceful in any particular way, right? So, and remember the spirit behind the international treaty in this particular framework. It's really designed not only to criminally, and herein lies the basis for the Commerce Clause argument. It's not only intended to penalize people who use or stockpile chemical weapons. It's also intended as a device to stop trafficking and trade in it, but at the same time not have a chilling effect, for example, on research and development and proper use of some of these particular chemicals, because as you know, chemicals aren't intrinsically good or evil. It's the deployment, right? And sometimes, bad stuff on your mailbox can be good stuff, right, if you're utilizing it for other kinds of purposes. So there is this peaceful purpose argument, but I doubt that's going to get any legs. Although it would be a way for the court to essentially find for petitioner, in a sense, cabin federal excesses, let's say, in this area, federal encroachment on police power, let's say, without touching the much more existential question of the precedential value of Holmes, albeit some would say Holmes' statements in Missouri are dicta, but the value of that over time as constitutional doctrine, and these other much more thorny issues of how does this affect the nation's ability to negotiate and implement international treaties. And remember, the root of the treaty power in many ways is at the time all of these concepts were being framed, it was not guaranteed in any way, and in fact the practice was the opposite, that the states would necessarily abide by the United States' international obligations and commitments. And that's in many ways why the treaty power was given a certain girth and breadth at that particular time. So, yes, I'm done. Yes. Thank you.
I also want to thank everybody for coming this afternoon. I'm putting on my election law hat today to talk about Mccutcheon versus FEC, which is going to be argued in front of the Supreme Court next Tuesday, October 8th. And the issue in the case is whether the aggregate limit for contributions to federal candidates and political committees under the Federal Election Campaign Act, also called FECA, is unconstitutional under the First Amendment because it interferes with individuals' rights to free speech and association under that amendment. And this addresses obviously an important issue left undecided in a case that some of you might have heard of, Citizens United versus the Federal Elections Commission in 2010. So I'm going to try and do three things today to talk about Mccutcheon. The first, I'll try to accomplish Mission Impossible and talk about campaign finance law and give you some summary of it in 10 minutes or less to set the stage. I'll then talk about the Mccutcheon case itself, and then finally some of the implications that may occur depending on how that case turns out. So campaign finance is a pretty complex area of legal doctrine. It involves an underlying tension between competing claims of associational rights, free speech rights, and political participation under the First Amendment on one hand, and on the other hand, the rights of citizens to design a democratic regime that is both viewed as fair and legitimate. And so we might think of the history of campaign finance as involving a multi-actor process where Congress takes some action to regulate campaign contributions and expenditures. There are then judicial challenges to that law. Well-funded individuals and organizations then attempt to exploit the quote-unquote loopholes that have emerged either from judicial decision or things that were not contemplated in the law, and then Congress reacts by passing a new law that attempts to close some of these loopholes. So the primary act and what's at issue here is FECA, passed in 1974 in the wake of the Watergate scandal, and sort of one perhaps underappreciated aspect of Watergate was some of the information that was learned about the money laundering at Nixon's re-election campaign organization appropriately called CREEP. And some of the money that was actually fundraised, I think it was $400,000, was actually used to pay off the Watergate burglars. And this was created an impetus to have some attempt to regulate federal contributions and expenditures in campaigns. And so FECA really set up sort of two main principles. The first one is it created limits on campaign contributions, both individual limits to what any one person could give to a candidate or a party, as well as an overall aggregate contribution limit that person could give to all federal candidates and party committees combined. It also created limits, so that's one hand we've got the contribution limits. On the other hand, we've got campaign expenditure limits. It also purported to set up a system about how much each candidate and party could spend in a federal election. And then it created the Federal Election Commission to enforce that act. And then the most significant case, at least until Citizens United, the Buckley versus Vallejo decision by the Supreme Court in 1976, which was a facial challenge to FECA. Very lengthy decision, over 300 pages, so I don't encourage you to read it. I'll briefly summarize it. So on one hand, it struck down the expenditure limits, applying a strict scrutiny standard, found that it violated individuals' First Amendment rights of free speech and association. Specifically, it rejected the rationale that Congress can't attempt to equalize influence in the democratic process by limiting others' ability to spend money to express their views on candidates and issues. On the other hand, though, it looked at contributions, and it applied an intermediate type scrutiny and said that the campaign contributions were constitutional, and the particular interest, the governmental interest involved in upholding campaign contributions was designed to prevent the corruption or appearance of corruption. That's kind of the buzz phrase that appears in quite a few cases. So one hand struck down expenditure limits by individuals, by campaigns and candidates, but affirmed limits on what you can contribute to parties and to candidates directly. The next major statute, the Bipartisan Campaign Reform Act, also called McCain-Feingold in 2002, attempted to close a couple of loopholes that emerged. One of those was what was called the soft money loophole, So FECA only regulated federal contributions and expenditures. It did not purport to regulate contributions for state and local elections. And so one creative way to dodge the campaign contribution limits was to give money to state and local parties that they could then use in activities such as voter registration drives, get out the vote efforts, generic party advertising would benefit both federal and state and local candidates. So McCain-Feingold attempted to close that loophole. It also prohibited what was called electioneering communications in Section 203, where the use of corporate and union treasury funds that clearly identify a candidate within a certain time period before a primary and general election. And it also included the stand by your ad provision, so you all have seen the ads that say, I am so-and-so and I endorse this message. You can thank McCain-Feingold for that provision. McCain-Feingold had been whittled away by a number of additional Supreme Court cases, the most recent of which was Citizens United, which struck down the electioneering communication provision in 203, and it held that under the First Amendment it was unconstitutional to prohibit individual expenditures that were not coordinated with a campaign by corporations, associations, and labor unions. This leads to the rise of super PACs that we saw in the 2010 presidential election. So on one hand, the short summary is that campaign limits on expenditures now are almost entirely gone, but the other pillar of FECA, limits on contributions, still for the most part has been found constitutional. And that's really what's at issue in this case here. Are these contribution limits still constitutional? And so just so that you know what the limits are right now, any individual, you can give $2,600 per candidate, per federal candidate per election. So primary and general election, you can give up to $5,200 combined. You can give $32,400 in national party committees. And there's an aggregate limit of $123,000 and change per 2-year election cycle for any individual or PAC. Somewhat surprisingly, approximately 2,000 people maxed out on this contribution limit in the 2010 presidential election, according to OpenSecrets.org. And so this is really what's the importance of this, whether people who've already given $123,000 and change to federal candidates and parties can give more money if this is struck down. Okay, so the factual background about this case, who is Mccutcheon? Mccutcheon is a treasurer of a super PAC called the Conservative Action Fund, and during the 2011-2012 federal election cycle, he contributed to 16 federal candidates, but he also wanted to contribute to 12 others, but he wasn't allowed to do so under FECA. Mccutcheon was recently quoted as saying, I just want to donate to more candidates. Why am I not free to spend my money however I want? And so he sued to challenge the aggregate contribution limit. 3-judge panel, the district court in D.C., rejected his challenges. It relied on Buckley in finding that contribution limits are subject to a lower level of review, again, repeating the intermediate standard of scrutiny articulated in Buckley because it implicates a contributor's associational rights more than their free speech rights. And in terms of what was the legitimate government interest here that justified this restriction, the court found that eliminating the aggregate contribution limit would allow evasion of the individual contribution limits by setting up what we call a joint fundraising committee that a candidate could work with a national party. You could give up to $500,000 to the national party in this joint fundraising committee. The individual candidate would only get their $2,600 or $5,200 if they had 2 elections. The rest of it would then go to the national party committee, and the national party committee could then spend it in a coordinated campaign with the candidate. So in essence, it would sort of effectively sort of destroy, at least in form, if not in, at least in reality, if not in practice, the individual contribution limit. And one kind of interesting quote here from Judge Janice Rogers Brown's opinion. She said, the candidate who knows this coordinated expenditure derives from that single large check at the joint fundraising event will know precisely where to lay the wreath of gratitude when it comes to enacting legislation. Okay, so what are the parties' arguments here? So Mccutcheon is reiterating his argument here. He wants the court to revisit the distinction made in Buckley versus Vallejo between the limits on contributions made directly to political candidates and party committees, and they said that they should be treated under the same level of scrutiny as campaign expenditures and subject to strict scrutiny. And he argues here that The existing limits would fail strict scrutiny because they're not narrowly tailored to promote a compelling governmental interest. The Federal Election Commission, represented by the Solicitor General, has argued that the justices should not revisit or revise Buckley's strict scrutiny standard for contributions. It says that Mccutcheon's provided no sound argument to overrule Buckley's longstanding distinction between contribution limits and expenditure limits. Lots of amici, as you might not be surprised, are interested in this. There have at least been approximately 20 amici at last count have weighed in on this issue as well. Okay, so the potential impact, what's at stake? I already suggested here there are quite a few people who have already contributed the aggregate limit and who might be willing to donate more. To give you a sense of sort of what kind of money we're dealing with here, 1998 election cycle, non-presidential, according to Open Secrets, $1.6 billion was spent in federal elections and candidates. 2000 presidential cycle, $3.1 billion. 2012, $6.2 billion. So the question here is, if we repeal these aggregate contribution limits, will it result in increased overall campaign expenditures, or perhaps will it lead more to a shift from what is now called independent expenditures? I'm spending my money by myself. One issue here is it going to increase overall campaign expenditures or just shift them from independent expenditures to coordinated ones given directly to candidates and party committees? And if we suggest that the latter is true, that we're going to see more of a shift in existing money rather than new money being added, the shift going from independent expenditures directly to candidates and parties, is the latter actually potentially preferable given the lack of disclosure requirements that exist for many so-called super PACs? And I'll finally leave you with a quote from Mccutcheon. He was actually, the New York Times article just came out yesterday on this case, and his quote said, "I think we need to spend more money on politics, not less." So I'll go ahead and take any questions that you have about this case. Okay, thanks.
I'll thank all of you as well. I think it's pretty hazardous to wade in at this late stage in the afternoon with a case on administrative law. I'm sorry, Brian, but a case on administrative law dealing with the Environmental Protection Agency, but I'm going to do it anyway. And I want you to imagine how beautiful it is outside. And instead of imagining yourself outside here in Lexington, instead you're maybe driving, as you might often be attempted to do, westward through central Pennsylvania along none other than the William Penn Highway. And just as you pass Ebensburg, Pennsylvania, you will glimpse something remarkable. 30 miles away from Ebensburg, you will spy the 1,271-foot smokestack of the Unit 3 coal-fired Homer City electricity generating station. Yes, 30 miles away. The stack is the third tallest smokestack in the world and is proudly America's tallest smokestack. Before it was retired, sadly, in 2002, the Unit 3 stack funneled its share of Homer City's annual 68 metric tons of sulfur dioxide into the lower stratosphere. Don't worry, its three shorter siblings, although despite maybe the complex they have carried on this dirty work. And in 2010, while providing electricity for 2 million households, the Homer City generating station was the largest source of sulfur dioxide pollution in the country. These tall smokestacks are representative of an old truism in the pollution business, and maybe no one could put this better than the sort of deadpan bureaucratic speak of the EPA. They explain on their website, taller smokestacks can lift pollutants high above the local community, helping these pollutants reach wind currents that can carry them hundreds, even 1,000 miles away. To which, you could only add something like a hard rain is going to fall somewhere else. Precisely this problem, this old gambit in environmental industrial activity, this problem has come to be known as interstate or transboundary pollution, and it's been a problem for the American states and our federal system for more than 100 years. At the turn of the last century, Georgia knowing that it would beat Tennessee in football, was nonetheless bothered by the fact that the copper company Smelter in Ducktown, Tennessee, was sending noxious fumes across the border and destroying crops and vegetation. Declaring this interstate air pollution a public nuisance, none other than our beloved Justice Holmes articulated what he called a federal duty of good neighborliness among the states. This is how he described it. It is a fair and reasonable demand on the part of a sovereign that the air over its territory should not be polluted on a great scale, that the forests on its lovely, I'm embellishing a bit, that the forests on its lovely mountains should not be destroyed or threatened by the act of persons beyond its control, and that the crops and orchards bearing fruit in the harvest should not be endangered from the same source. And that is Georgia versus Tennessee Copper, 1907. I first became aware of this remarkable expression of inter-sovereign solidarity in the international environmental law setting, in a transboundary air pollution dispute from the 1930s involving a Canadian smelter with its own tall smokestacks that were belching pollutants down along the Columbia River and destroying crops and vegetation in Washington state. An international arbitral panel was summoned to solve this dispute between these hostile neighbors, the United States and Canada. And desperate as they were, the arbiters cast about in vain for a rule in international law to solve this problem of interstate air pollution. To their credit, they resorted to the best law available, that is, the U.S. Supreme Court's Georgia case. And they fashioned what has come to be known as the Trail Smelter Rule in international environmental law. No state has the right to use or permit its territory in such a manner as to cause injury by fumes in or to the territory of another, of the properties of persons therein, when the case is of serious consequence and the injury is established by clear and convincing evidence. Both rules, the Georgia rule and the Trail Smelter rule, involve a mix of very important and complex principles of state sovereignty, of precaution with respect to environmental regulation, and of course also sustainability. The Trail Smelter rule is so effective in imagining how to balance those interests that it's often been regarded as the wellspring of international environmental law. All right, so considering this pedigree of American law with respect to this particular issue, I think it's a little bit more than ironic that the case that I'm presenting today demonstrates just how intractable this problem is with respect to the United States and the relations between the states and our union. American Lung Association versus EME, Homer City Generation, is at its core just another interstate pollution case. Upwind states have always, and it seems they will continue to try to, externalize their pollution problems, destroying vegetation, eroding human health, and inflaming interstate relations with every gust of wind. Our federal system of open borders, in essence, seems to confirm just the slightest adaptation of Robert Frost's old adage, maybe only fences, real fences, and in this case very tall ones, would make the best neighbors. The Clean Air Act might just be that kind of fence. It aspired to protect America's public health and welfare through a nationwide regime to control air pollution. And in that, it could hardly ignore or avoid the problem of interstate pollution, as it sought to work with and through the states to establish and enforce national air quality standards. And as part of the Clean Air Act and the state implementation plans that it requires, states must propose, and here it is, this is Holmes' moment, this is the Trail Smelter moment of the Clean Air Act, this is the good neighbor rule in the Clean Air Act. States must propose rules that will prohibit pollution, that will contribute significantly to other states' inability to meet or maintain compliance with national air quality standards. And that is the codification of the good neighbor principle. In addition, that's relevant to the case, a state's failure to propose an adequate implementation plan, including this good neighbor demand. Its failure to propose an adequate implementation plan empowers the EPA to impose its own federal implementation plan. For reasons that aren't exactly clear to me, no state ever in the 40 years of the Clean Air Act seems to have submitted a state implementation plan. And instead, the federal government has repeatedly sought to avail itself of its power to impose its own federal implementation plan. That has been repeatedly challenged. The latest iteration contains the necessary good neighbor policy. The EPA calls it the transport rule. The transport rule is meant to be the mechanism for addressing the interstate air pollution requirements of the Clean Air Act, and the transport rule sought to achieve that goal in a two-step process. First, it had to define who the bad guys were, who are the upwind polluting states, and then secondly, it had to figure out how to make them stop. In the first case, the definitional element of the transport rule created a standard that designated 28 states, mostly in the Midwest, Northeast, and in Texas, including Texas. It designated 28 states as, quote, significant contributors to a number of downwind states' failure to comply with the Clean Air Act. And these upwind states, the EPA said, contributed very large portion of downwind states' failure to comply. And a few examples, the EPA pointed out that in several downwind counties, 90% of the county's failure to meet their air quality standards was attributable to upwind state pollution. In the second step, the prohibition element, the transport rule created, and this is the problem that gets us into administrative law, the transport rule created a complex, differentiated system for prohibiting the upwind states' interstate pollution. Now, the EPA might have simply adopted a straightforward quota. Every upwind state has to prevent this amount of pollution and in that way contribute to the reduction of the downwind problem. Instead, the EPA excluded some of the 28 states from any responsibility at all, and then the remaining states were given quotas to meet with respect to reduction on the basis of two factors. First, the transport rule determines how much a state's reduction, that is an upwind state's reduction, would actually impact downwind states' compliance. And then secondly, the transport rule seeks to identify the cost of achieving emissions reductions. Okay, that's complicated, but the EPA's motivation is fairly clear. It's aiming, through the transport rule, to demand reductions from polluters that can achieve the greatest impact on downwind states' pollution problems at the lowest possible cost. The EPA's transport rule, as all of its previous work in this field, was challenged by upwind states and by industry, and in a 2-to-1 decision, the D.C. Circuit vacated the transport rule, citing several concerns. The first two are related. The first concern is that the differential treatment, this different treatment that some states were excluded altogether, some of the 28 offending states were excluded altogether, and of the remaining offending states, they were given differentiated responsibility for reductions. The District Circuit said that this differentiated treatment actually violated or was not authorized by the Clean Air Act explicitly. So this is a direct violation of the Clean Air Act's commands for the EPA, in essence. But the District Circuit went one step further and said, not only is this contrary to the commands of the Clean Air Act itself, it violates the spirit of the Clean Air Act, which calls for that more straightforward proportional responsibility. Each state should simply have a direct quota for its reduction without weighing the cost effectiveness of reducing its emissions. All right. The American Spectator called D.C. Circuit's decision a stake in the heart of Obama's war on American coal, and in fact, the day after the Supreme Court granted certiorari in consolidated challenges that had been brought by the EPA and environmentally concerned organizations, America's two largest coal producers saw their share prices drop by more than 5%. Right, there are intense political concerns implicated in this case, but it also involves some really difficult issues of fact and law. And these are difficulties, I think, that lay at the heart of all transboundary environmental regimes, whether they're domestic or international. I hinted at this earlier, but this is sometimes simply called the externality problem. But in its various parts, it consists of things like this: a very technical problem that is barely susceptible to scientific modeling because it involves complex emissions regimes, the desperate attempt to track wind currents, and a way of trying to measure actual impacts somewhere. That is all operating in the face of different jurisdictions being involved with differentiated responsibility, and that's set against expectations in law of comity, equality, and sovereignty. And all of that, again, as I might have hinted earlier, is also meant to be resolved with some hope of promoting sustainability and ongoing economic viability. All right. I think those are the really big, compelling questions in the case. But there's another way to take a look at it, and that is to say that it might just be an ordinary administrative law case, concerned chiefly with the judiciary's jurisdiction in Clean Air Act challenges. And if that's not a problem, that is, if jurisdiction exists, then the classic administrative law issue is here, which is simply the court's deference that they're expected to show to agencies' interpretations of statutory regimes that result in agency rules, like the transport rule. The issue of judicial deference is clearly before the court, which has been asked, among the several questions presented, whether the EPA could use cost abatement analysis in defining upwind states' significant contribution. And that's the part that created this differentiated responsibility. Or whether the D.C. Circuit concluded, or whether, as the D.C. Circuit concluded, the agency is limited to only determining physical proportional responsibility from the states. Okay, the petitioners have argued that the D.C. Circuit went way beyond its authority, considering what you all understand now to be the deference it owes to agencies like the EPA. It exceeded its authority in the first instance by basing its decision, the petitioners say, on concerns that had not properly been raised during the public comments review process of the transport rule. And we understand that that exhaustion requirement prioritizes agency expertise in highly technical issues like this. The petitioners also say that the D.C. Circuit abandoned general principles of judicial deference to agencies. That is, there were clearly ambiguous terms in the Clean Air Act, like significant contributor, and the agency pursued carefully considered approach when acting upon these ambiguous terms. As evidence of the EPA's conscientious approach with respect to the transport rule, the petitioners argue that the EPA acted consistent with the Clean Air Act's text. It imposed a regime that is calibrated to work in the real world, and that the agency stayed within the limits of its authority. The deference the petitioners demand for the EPA's transport rule derives, as all of you in your expertise now know, from the Supreme Court's seminal Chevron case, which sought to limit judicial review of agency decisions to a two-step process. First, the court should determine whether the underlying empowering statute creates some ambiguity. And second, if that's the case, the court is charged with determining whether the agency's choice for resolving that ambiguity was reasonable and was permitted by the statute. Judicial deference of agency decisions was reaffirmed again by the Supreme Court last spring in Arlington versus FCC, with Justice Scalia writing for the majority. And if it's true that this is a straightforward administrative law case, you might wonder why the Supreme Court took the cert. In light of the court's recent decision in Arlington, one might read the court's grant of cert as an attempt by the Supreme Court to bring the D.C. Circuit in line with its insistence on judicial deference. That is, it's trying to reinforce its message to the D.C. court. On the other hand, the Roberts Court has built up a clear pro-business record, including the 2008 decision in Exxon versus Baker, and last term's Monsanto decision regarding intellectual property interests of that corporation. And I have one other interest, and then I'll end with respect to this case, the interest that draws me to it. The case presents, for me, three distinct visions of federalism. And that's not necessarily the rule or the legal issue upon which the case will be decided, but the decision will say something about American federalism. This may not surprise my students about my fixation with federalism. But the Roberts Court's decision here will end up making a decision between three possible models of federalism. And I want to suggest what they are. The first is the vision of federalism anticipated by the Clean Air Act itself. That is, the federal government operating in cooperation with the states to manage their relationships with one another and to achieve a national goal. And that might be something like a cooperative vision of federalism. But there's another possibility, the possibility offered by the D.C. Circuit here, and that is of a strictly sovereign approach to the rights of our states. That is, the court, the D.C. Circuit Court, is saying that the EPA failed by not treating each of the state sovereigns as autonomous, distinct equals. And there's a third vision that is embedded, I think, in the Holmes good neighbor rule, and it's an area of federalism that is often neglected in much constitutional law thinking. And that is the area of federalism that relates to the relationship between the states and not the relationship of the states to the federal government. And that vision is a vision of solidarity, and more importantly, not just a vision of solidarity between the states, but it may actually be the only vision that will make addressing transboundary interstate pollution issues, not to even mention something like climate change, possible. I'll leave it with that and take some questions if there are any. Thanks so much.
We have time for sort of one or two very brief questions, and we can follow up with this.
Super brief questions. Yes. Yeah. Wow! Man! No way. I'm digging in now, Spike. Yeah. We can avoid that problem by no questions, I suppose. Yeah, thank you.
Well, good afternoon. You have been sitting patiently for an hour and more. So I think it's time for a good criminal case, Bert versus Titlow, which is a tale of murder most foul and a greedy, unscrupulous, and disbarred lawyer. Sound good? So this can be your seventh inning stretch. Bert versus Titlow is a habeas corpus case. And let me back up. This is the 50th anniversary of Gideon versus Wainwright. As you all know, the famous case that recognized that the right to counsel is part of due process of law under the 14th Amendment. It would be another 21 years after Gideon that the Supreme Court recognized that the right to an attorney means a right to an effective attorney in Strickland versus Washington. And it would be another 27 years before the court recognized that the right to an effective attorney does not only kick in a trial, a jury trial or a bench trial, but also has to be given meaning in the 95% of all the criminal cases that involve dispositions other than by trial. That is to say, in almost all of those cases, by guilty pleas, and in the vast majority of those cases, by negotiated guilty pleas. This country has 2.3 million prisoners. We incarcerate more people than any other country in the world by far, and the vast majority of those people are in prison pursuant to a judgment that involved plea negotiation. And finally, in 2011, the Supreme Court recognized that that process by which so many people have been incarcerated, and many of them for so long, is not immune from review under the Sixth Amendment and under the case law involving the right to an effective attorney, an attorney who understands the law before he or she advises the client, who takes time with the client, an attorney who investigates the facts, who knows what the client's actual situation is, and who communicates plea offers from the prosecution when they're made. The very most basic and elementary responsibility of a criminal defense lawyer in the vast majority of cases that go through the courts. Bert versus Titlow is a case in the aftermath of this first recognition, 2 cases 2 years ago that said, yes, a client's right to counsel can be violated if the client's lawyer performs incompetently in the process of plea negotiations. And then a whole host of very difficult, perplexing questions arise about how do the courts enforce this right, and what is the remedy when a plea negotiation goes off the rail because of the incompetent or ineffective or downright corrupt performance, as we have here, of a lawyer. Okay, this case involves what could only be described as a cartoonish level of villainy on one hand, and of corruption and selfishness and greed on the part of the lawyer involved on the other. So it is a colorful story, and I will outline it in about a minute or two. Donald and Billy Rogers were an elderly couple of considerable means, and Billy decided, the wife, decided that she would rather be Donald's widow and have his money than his loving spouse. He was a man with a drinking problem, and it was thought that his death could be made to seem like an accident if he was forcibly ingested with more alcohol than he could survive. So with the help, and the amount of help is the contested issue, of Billy and Donald's nephew, which, just in case this couldn't be any more confusing, was his nephew at the time of the crime, but is now his niece. Because Mr./Ms. Titlow is a transgender person who now identifies as a woman, but was identified as a man at the time of the crime. So in the Supreme Court pleadings, it is a she. Held down Donald while Billy poured vodka down his throat, held his mouth shut. It wasn't working. He wasn't dying from alcohol poisoning. It then became necessary to smother Donald, and the question became, what was Von Lee Nicole Titlow's exact role in the smotheration of this old man? Her story is that Billy did all the smothering, and he was not even in the room and was not fully aware that there was a plan to kill him at all. Billy's story was something different. What happens is that she confides about this crime to a boyfriend who goes to the police, is fitted with a wire. Incriminating statements by then Mr. Titlow were recorded. Both he and Billy were arrested. He then passes a polygraph test on the question of whether or not he knew that there was going to be a killing, and armed with this information and a few other things, his lawyer is able to negotiate a plea offer to reducing first-degree murder to voluntary manslaughter and a recommendation of 7 to 15 years, minimum 7 years. Not a bad deal, all things considered. The plea is entered, and then Mr. Titlow goes to jail. There is some dispute about exactly what happens, but we do know that a deputy sheriff sensed that or heard that Titlow felt that he was not really guilty of this crime, and says, well, if you're not guilty, you shouldn't plead guilty. Why don't you talk to my lawyer? The the sheriff's lawyer. So he did, who referred him to another lawyer. Both of these lawyers are no longer lawyers, by the way. Enter one Frederick Toka, the lawyer at the end of this chain of referrals, who meets with Titlow and says, you are not being well represented, I will represent you, you should go to trial, you should withdraw your plea, and the fee will be raised by selling the rights to your story for publication and television and movies, up to an amount of $100,000. And they write this out by hand on a scrap of paper. So, the representation is on the way. Mr. Toka did not, however, do a few other things, like talk to the lawyer who negotiated the plea, look at the state's file, look at the defense file, indeed do any factual investigation whatsoever about why the first lawyer had thought that the best thing to do was to negotiate this guilty plea. Things went south for Mr. Toka rather quickly when he discovered that the story wasn't selling and that there was no $100,000 to be had. And he therefore withdrew from the case. Another lawyer was appointed, and the case was very quickly went to trial. Titlow was convicted of second-degree murder and sentenced to 20 to 40 years, roughly 3 times the sentence that would have been had on the deal. Goes into eventually into federal habeas corpus, and a federal appeals court finds, for reasons that I think you can understand, that Mr. Toka had denied Titlow the effective representation of counsel when he blew up the plea agreement without the least bit of information about whether it was a good deal or a bad deal, and had violated every conceivable duty that a lawyer owes to a client, and had done so for reasons that could only be described as greedy and corrupt. That was a denial of the effective assistance of counsel. The question then becomes what is to be done about it. And the Sixth Circuit held that the original plea offer had to be re-offered. That he had to go back to the trial court, and the prosecution had to say, we'll let you plead guilty to voluntary manslaughter with a much lower range of punishments. The rub was that part of the original plea deal was that Von Lee Nicole was going to testify against Billy, the would-be widow. And he refused to do that as part, when he withdrew from the plea, she was tried without his testimony and was acquitted. So the deal could no longer be stitched together. Needless to say, the state is now irate that they should have to re-offer the plea deal when they haven't gotten their benefit part of the bargain. But on the other side of the coin, if there is a constitutional right to be represented by a lawyer that, at least at some low elementary level, does his or her job, surely we can agree that that constitutional right was violated in this instance. And can there be a violation of a right with no remedy? Too bad. You're stuck. Do your 20 to 40. Serves you right. You should have gotten a better lawyer. Clients in these situations are pretty helpless in the hands of lawyers. They are utterly dependent on the advice of a lawyer, and when a lawyer does you like that, most clients are not going to be able to protect their own interests. That's why we have lawyers. So those are the questions before the Supreme Court. It's complicated by the fact that it arises on federal habeas corpus, a statute which has been protecting, or has been supposed to be protecting, state prisoners from violations of the federal Constitution ever since the Civil War, but was converted into a almost incomprehensible mass of technicalities when Congress set out to reform habeas law in 1996, and now is so enmeshed with rules of deference and complicated doctrines to say that federal courts cannot grant relief when there has simply been a constitutional violation, but must establish that the constitutional violation is so outrageously obvious as to be completely off the charts. And so there is always a sort of a haze between what happened to a habeas petitioner and the federal court's power to do anything about it, and how thick that haze is and what it allows and prevents the federal courts to do comes up in every federal habeas case, which means that the holding in this case could be very hedged and difficult to interpret, or it could be quite clear. The court is being asked, for example, to say that when someone claims that they would have pled guilty and taken a plea bargain, but for the bad advice of their lawyer. There should be a special rule of evidence that more is required than only the testimony of the prisoner, him or herself, a rule which is not found in other areas, but would certainly make it much more difficult for for prisoners who have been wronged by their lawyers to be able to prove it. And then there is the question of how much power a federal court has to order a remedy, or is it enough that the case simply gets sent back to the state court where the state judge will decide what remedy to offer, if any at all, or none. That is, those are the stakes in this, that arise from this extremely unusual fact pattern. People say it's always difficult to predict what the United States Supreme Court is going to do, but I don't think it is difficult to predict that Ms. Titlow is going to lose. The real question is exactly how, and whether the case will be an odd and peculiar sounding melodrama in the United States reports, or whether it will actually undo a great deal of the rights that were recognized just 2 years ago when the Supreme Court, for the first time, recognized the crucial importance of the plea bargaining process and the importance of recognizing the right to effective representation in that in the enormous majority of criminal cases that go through our courts, state and federal courts every year. Case is going to be argued 6 days from now, next Tuesday, and we'll see what happens. Thank you. There isn't any time if there was, but...
Let me start by thanking Andrea Hilton for putting this event together. We really appreciate it. It's taken a lot of work, and it's been fun already. This is the bad part right now. But in NLRB versus Canning, a federal agency issued a civil enforcement complaint against a bottling company, saying the company had violated federal labor law. The company defended itself with legal arguments. One of them was that the agency had no power to bring any kind of action against the company. The argument was that the labor statute requires a quorum of 3 members before the board can act as a board. But there had been no quorum in this case. Well, why hadn't there been? Because, argued the bottling company, only 2 of the 5 agency heads had been constitutionally appointed to the office. Hence, no quorum of 3 valid members had acted, and hence the matter should be thrown out, eviscerated, trashed, and sent packing. Now, we know that in administrative law, this is how a lot of major cases wend their way up to the Supreme Court. An agency tries to enforce the law against somebody, and that party defends by raising a constitutional attack on the agency's very power to proceed. Here, the attack was based on the recess appointments clause, a very obscure little pathway, a rivulet, a kind of bog in Article 2 of the U.S. Constitution. It's 1 sentence long, and it says, "The President shall have power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their next session." So according to the bottling company, President Obama's appointment of 3 of the 5 NLRB members on January 4th, 2012, did not take place during, quote, the recess of the Senate, and so did not follow the requirements of the recess appointments clause. The company says that the clause, by using the phrase "the recess," had only one kind of recess in mind: the recess between a formal enumerated session of Congress, known as an intersession recess. Pursuant to the Constitution, the second session of the 112th Congress began at noon on January 3rd, 2012. So the president's appointment of the 3 board members the next day, said the bottling company, did not take place in the recess between 2 sessions, but during an adjournment, at best an intra-session recess of the newly begun session. That's one argument made by Cannon. In addition, the company argued that the vacancies being filled didn't, quote, happen during the recess of the Senate, so that the appointments failed for that reason as well. The D.C. Circuit accepted both arguments, found the appointments unconstitutional, gave the company its remedy. That's the issue before the U.S. Supreme Court. Was the D.C. Circuit's pretty literal and originalist sounding opinion correct, or is there another way to look at this? Now, before we get to the rationale of the court, let's back up and look at the recess appointments clause in the grand scheme of administrative government. A few basics, please remember. First, Article 2, what does it do? It vests the executive power of the federal government in a president of the United States, and it gives the president, quote, the duty to what? Take care that the laws be faithfully executed. Of course, the president can't execute all the laws by himself, so Article 2 also gives the president the appointments power through the appointments clause, which provides how subordinates are to be appointed to office. The appointments clause provides, yes, that the president nominates the person and submits his or her name to the Senate for advice and consent. If the Senate confirms the appointment is made and the President commissions the officers. The Senate's confirmation power is one of the checks and balances written into the Constitution, that main executive officers have to be approved by both the Senate and the President. Those who applaud the D.C. Circuit's decision in this case, those who applaud it, see that opinion as faithful to constitutional text and as a salutary check on the ever-expanding presidential powers. Those who denounce the D.C. Circuit opinion see it as wrongly dismissive of long-standing presidential practice to make intra-session appointments to fill vacancies that didn't happen during the recess, but that happened to exist, that is, preceded the recess. So the government wants the court, the U.S. Supreme Court, to advance the purpose of the recess appointments clause, that of enabling the president to assemble a team and to keep the government going. Whereas the other side highlights the checks and balances of Senate confirmation and thinks that a broad reading of the recess appointments clause would eradicate the Senate's role. Okay, so what's the practical problem in all this doctrinal yelling and screaming? The practical problem is that the confirmation process, as we know, is the bumpiest of all Washington processes. It's like a very long, involved, and ultimately dull miniseries. Since administrative agencies, particularly the NLRB, are engaged in politically controversial policy issues and enforcement, numerous presidents of both parties have had trouble getting their nominees to this agency confirmed by the Senate. It's especially hard now. Why? What's especially tough now? One party occupies the White House, another party dominates the House, and the filibuster is in full swing in the Senate. The confirmation process then becomes the occasion for drama, not necessarily about the credentials of the nominees, but about the agency's policy and direction. Currently, the Senate Republicans are objecting to a number of appointments, but in 2007, the Senate Democrats were the objectors, and in each case, the president asked his legal counsel whether he could just bypass the Senate by using the recess appointments clause. George Bush asked his counselors that. President Obama asked his counselor, can I just bypass the Senate and get some of these people confirmed? even if temporarily, without Senate confirmation? Can I bypass the Senate altogether? So the doctrinal questions become pretty intense when you know that that's what this is about. What does the recess of the Senate mean in the Constitution? And is there some requirement about when the vacancies are supposed to arise? All right, I'm almost done. According to the Federalist Papers, Alexander Hamilton wrote a whole paper about the Recess Appointments Clause, and he pointed out why this thing was even dreamed up in the beginning. It was needed in the first place because Congress wasn't going to be in session long at all during the year. Congress would be in session only a fraction of the year back then and could not quickly return to the Capitol during the long recesses between sessions, and the president wouldn't be able to fill vacancies that arise because the Senate wasn't present to confirm. So Hamilton's point was that the recess appointments power allowed appointment without confirmation to help keep the government functioning while the Senate was gone. Nowadays, obviously, the problem isn't so much physical or geographical, it's political. Senate confirmation isn't impeded because of geographical distances, but because of political strife. And okay, here's what's developed. A certain dynamic has developed. Presidents, no matter who the president is, presidents seek to stretch the range of discretion under the recess appointments power to the max, often based on self-serving statements and practices of past presidents that current presidents want to say provides a gloss on the meaning of the Constitution. Okay, that's part of the dynamic. And meanwhile, the Senate or the House, through its own circuitous route of having the constitutional power, yes, to forbid the Senate from adjourning for more than 3 days, the Senate and the House try to make sure that a recess never really happens. So the presidents try to expand the recess power, and the House and the Senate have their own ploys to make sure that an intercession recess never happens. Metaphysically, it just doesn't happen. That's what happened here. In 2011, this is great, as the holidays approached in 2011, the Senate wound down its work. But under Article 1 of the Constitution, the Senate, I said, can't adjourn for more than 3 days without the consent of the other chamber, the House. Republicans dominating the House didn't want to consent to a holiday recess for more than 3 days because a more than 3 day break would amount to a recess and simply invite President Obama to make some recess appointments. So the Senate, and this is interesting, by unanimous consent, the Senate adopts an order providing that between December 17th, when they wanted to go home, and January 23rd, when they were willing to grudgingly come back, the Senate would, get this, you probably know this, but the idea was that during those 2 dates, the Senate would unilaterally, meaning without the House's consent, adjourn for just 3 days, reconvening every fourth day for about 30 seconds in what is known as a pro forma session, and then promptly adjourning for another 3 days, and then reconvening briefly for another pro forma session until the fourth week of the period was over and they grudgingly come back from the holidays. In other words, instead of taking a formal recess, the Senate would divide the time into a series of mini adjournments and 30-second sessions so that no one could claim that a recess had taken place, making it impossible for the president to make a recess appointment. Now, the president appreciated the cleverness of the dynamic since his own party had done this to George Bush in 2007. But President Obama had a ploy of his own. Very clever. His response was to call those mini breaks and pro forma sessions a sham, and to say that functionally the Senate was in recess, albeit an intra-session recess, because January 3rd had already come and under the Constitution the next session had begun. But he said, well, all that mini stuff is a sham, and so I'm going to call it a functional intra-session recess, and I'm just going to start appointing people willy-nilly. And that's what he did. The new session had begun at noon on January 3rd, and the president acted on January 4th. And he commissioned 3 new members of the NLRB without sending them to the Senate for confirmation. Some say the president was even cleverer than that he picked January 4th, the earliest possible day in the new session, because a recess appointment only expires at the end of the next session. So those 3 NLRB guys got the longest possible recess appointment. So the idea was that as long as the recess appointments clause was interpreted as allowing intra-session appointments, he could do that. Meanwhile, the Canning case